took my nephew to his elementary school in class the other day, and I watched the kids play during recess. One tough little first grader grabbed one of his classmates by the shirt and said, "Who's the toughest kid in first grade?" And you stammered, the little child. He went over to the next kid, and again he grabbed another kid by the shirt. He said, "Who's the toughest kid in first grade?" And the kid was, frightened. He said, You are. And finally he came up to the younger one, and another first grader, shoving his fist in the boy's face, and he demanded, "Who's the toughest kid in the first grade?" With this, the would-be victim retaliated, sweeping away the offending fist and knocking the attacker to the ground with a well-placed punch. "Hey," sobbed the ex-bully from the ground, "you didn't have to get sore about it just because you didn't know the right answer." That's what's happened with the family section of the Florida bar, ladies and gentlemen. We started to fight back. We have presented drafts of the alimony language that we would like. And we've done that for the last few years. And as you know, what happened was they came back with other drafts and they fought it and they fought it. These are the overall goals that we want to achieve. I'm going to go over some of these goals with you. Have the family section construct a draft trying to deal with these goals and bring it back to us. Let us look at this and let us work together. Supportive relationships, cohabitation, and that's a tough one. If you don't know, there are about, I think, 11 or 12 different parts of the cohabitation where you have to show that you're mixing funds, you're living together as husband and wife, and so forth and so on. What happened was a gentleman got divorced. His ex-wife remarried in Vegas. They had a wedding, they had a ceremony, they had rings, they came back and lived together as husband and wife. When he went back to court to try to modify his alimony, there was no marriage contract. So ultimately, they said that they weren't really married, they were just cohabitating, and there was nothing in the law to allow for modification of alimony under cohabitation. So he actually helped write all of that criteria that we have right now. And if you look at it at face value, it's good criteria. The problem is, judges have the ability to say, one of that criteria has to be filled, or all 11 have to be filled before we're going to agree that cohabitation is actually happening. The family section of the Florida bar has lost some credibility, I think they lost a lot of credibility, with the legislators over these last few years, because we've established our credibility with them. We're the first organization that has challenged the family section on their own terms and came out really ahead with supermajority votes on the House and the Senate.